Hello the world, hello the internet, hello Jason Isaacs. Is my bookshelf looking great? So let's crack on with another presentation. This one perhaps going to get some of our more excitable members of the audience revved up. This is about rights in the UK. So we'll be talking about what we have, what rights we don't have, and where those rights come from. And we'll be right back after the introduction. Cue the music and see you in a second. Right, so we're back. Hello again, and let's talk about the rights we have, the rights we don't have. Interesting little things coming up here. This one here, the Serious Organised Crime Police Act. Remember that one. Also, this one, Serious Organised Crime Police Act plus Brian Hoare. He is a fascist, racist. Well, that's freedom of speech, I'm afraid. And this guy is exercising his freedom of speech. This guy is exercising his freedom of speech. That's what it means to live in a parliamentary democracy, or Western liberal democracy, where we recognise the freedom of speech, but with that, the right to offend. Handgun laws in in the UK, very, very simple. Everything changed in 1997 after the attack in Dunblane, terrible attack in Dunblane. And we passed laws. The Parliament passed laws banning handguns in the UK. Bang. Firearms Amendment Act of 1997. After that, our rights changed because our rights change every time Parliament passes a law. That's essentially my thesis here. And I know that that's going to get some people excited because they want to talk about rights before 1998. And yes, we did have rights before 1998. Some of them were described by laws. Others were described by common laws, by statute laws, there we go. And others were declared by common law traditions and things that go all the way back. But yeah, Magna Carta 1215, Magna Carta was a pretty terrible bit of legislation anyway. It wasn't legislation, it was agreement. Hence Magna Carta. So yeah, the Magna Carta is there, that's it there. It's still, it's part of our constitution, but it has been superseded by common law, statute law, and indeed even these international treaties and agreements. We're going to talk about the ECHR in a minute. But think of it, before 1998 as this big patchwork of different ideas. Yes, dating all the way back to 1215 and onwards and upwards, constantly being updated. Because every time Parliament passes a law, effectively our rights change. We can see that when we look at the franchise. We'll start at 1832 and we can see here how a succession of laws changed who could vote and who couldn't vote, to the point where in 2000 we have almost universal representation. And yeah, that's it. Why is that the case? Well, because Parliament passed those laws giving people the right to vote. At all of those stages we see the franchise expanding through Parliament's legislation. Now, let's talk a little bit about the ECHR and the European Court of Human Rights, or the ECHR, the European Convention on Human Rights, and the EC small thr, the European Court of Human Rights. Now, we were one of the original signatories of the convention. In fact, we were one of the drafting parties of the European Convention on Human Rights, and we have a large number of British judges who sit in the European Court of Human Rights. Now, we are still signatories of the ECHR. We're still subject to the decisions made by the European Court of Human Rights. It's got nothing to do with the EU, or rather, it's kind of got something to do with the EU in that if you're going to be a member of the EU, then you are expected to have signed up to the ECHR. So sorry to those of you who thought that Brexit was going to change our relationship with the European Court of Human Rights. We're no longer subject to the jurisdiction of the European Court of Justice, but the European Convention, the European Court of Human Rights, we're still signatories of that until such time as we choose to disengage ourselves from the document that we signed in 1950, which would kind of be a weird thing to do, not least because we kind of drafted it and we have judges that sit on it. And also, since 1998, since we passed the Human Rights Act in particular, you'll see that we have tended to win, or we tended to lose, fewer cases. And this is very, very important for the way in which the European Court of Human Rights, and certainly the European Convention on Human Rights, relates back to our EC, to our own Human Rights Act, excuse me. But before I get on to that, I just want to make two more important points. First of all, The European Convention on Human Rights is not really admissible in UK courts. Now, it can be brought into the UK courts, but it's not binding on the UK courts because the UK courts are courts of law, and so what they uphold is the law passed by Parliament and indeed common law established by previous decisions. Again, my learned friends, if I'm saying something here that's completely wrong, my qualification is not in law, then do please feel free to point that out, but I'll take that from constitutional lawyers, please, and not someone who just feels very strongly on the subject. The key thing here is that the British courts can take the European Convention into consideration when they're making a judgment, but they're not necessarily bound by it because they are not really tied into that whole European court business. Now, if the European Court does decide that our legislation is incompatible with the European Convention on Human Rights, then its decision is purely advisory. Again, it's not necessarily binding. The European Court cannot strike down our laws. It can declare them incompatible. But even then, there's always a fair degree of latitude in that particular decision for the local courts to decide, for the local jurisdictions and legislatures to decide how to apply those EU laws. But I'm getting way ahead of that. The one I always remember here is Tyler, because that was the one that essentially ruled out beatings at school, which was probably quite a good thing. We'll come to Nicholson again later. But if you are interested in the relationship between the ECHR, British courts and the European Convention of Human Rights, then do please check out my video, which I'll try to link off here, on life sentences, where I do a massive deep dive into this issue, because it is fascinating. In essence, what it looks like is kind of like this. Before the before the Human Rights Act, Parliament could basically pass any law it liked. That's the nature of parliamentary sovereignty. Parliament can make, amend or set aside any legislation it deems fit. Now, we were signatories of the European Convention on Human Rights, and so if the legislation did not quite go through the European Convention on Human Rights, in other words, if somebody thought that Parliament's legislation was incompatible with the ECHR, then yes, that decision could be referred back to Strasbourg and they could have that discussion. But while that was happening, the laws would still be in full force because the European Court of Human Rights did not have, or does not have, the authority to strike down domestic legislation, which is why prisoners still cannot vote, or certain types of prisoners cannot vote, even though that is in direct contravention with a decision that was handed down by the European Court of Human Rights in 2005, if I remember correctly, when we promised we'd fix it. But we never quite got around to it. So we're still, again, I will defer to any of my legal friends. I understand we're still technically in breach of that decision, but things have moved on and people are thinking of other things. Something else happened 2008 and then 2016 and then 2020. Yeah, so we've been thinking of other things. One last thing on the ECHR at this point, if you are interested in it, this is a fantastic article by Sumption, which really shouldn't come as a massive surprise. He's a very, very clever chap. And so if you're interested in the relationship between Britain and the ECHR, I'm going to shut up, but do please follow this. I will link off to it in the comments at the end. Good. So what then is the Human Rights Act? Well, the simple thing is it is a law passed by Parliament, and this is where your rights are to be found. What rights do you have? Well, you can look at those rights that I mentioned earlier, but also look at the Human Rights Act, because to that patchwork of laws that I mentioned earlier, we have basically taken the European Convention of Human Rights and slapped on top of that the phrase, I've got my slides in the wrong order. Oh, I haven't even copied it across. That's really stupid. Basically, what we did was we took the European Convention of Human Rights and we crossed that out and wrote the Human Rights Act on across it. That really could have been better. Sorry about that. But basically, this is the European Convention on Human Rights with the Human Rights Act stamped across the top, and it then being passed by our Parliament. So we took the European Convention on Human Rights, we put that into British law, and we called it the Human Rights Act. And what that meant was that then, when previously Parliament could make, amend or set aside any legislation it deemed fit, what the Human Rights Act did effectively was to create a pre-filter on that. So here we are, we've got Parliament making law, we've got the European Convention of Human Rights, we've crossed that out, we've written the Human Rights Act across the top, and that imposes a legal obligation, a statutory obligation on Parliament to make sure that all of its legislation can fit through the Human Rights Act before it goes onto our statute books. Now, if later it is decided that a decision is not compatible with the Human Rights Act, then that goes to our courts, and they will try to find a way to reconcile that future law with the Human Rights Act. But in essence, the single most important thing to get across here is that our rights are described by laws, and in particular the Human Rights Act and those other laws that we mentioned earlier. And we'll come across a few more of those as we go through. The Human Rights Act, this is where we will find our rights in the main. Important point, I think, here is the difference between collective rights and individual rights. So the really important thing is that in the UK, rights are held by individuals and not by collectives. So we have an individual right for freedom of speech, but there is a collective obligation on people to allow other people to speak, even if you're finding what they say offensive. That's very, very important, and I'll touch upon that a little bit later. You can't incite violence, but there is in our law a big difference between inciting violence and just upsetting somebody. Those are not the same things, they're not equivalent. So our rights, again, are described by laws, the Human Rights Act being the single most important one. So here, for instance, we look at the freedom of expression. This is our freedom of speech, Article 10. Everyone has the right to freedom of expression. This is the right to hold opinions and receive and impart information, etc., etc., etc. Now, that is not without limits, and the law makes it clear that while you can say certain things, there are other things that you can't say, and those restrictions or penalties, as prescribed by law, necessary in a democratic society. And you're thinking about crime, you're thinking about protection of health or morals, you're talking about making sure that your words are not harming or threatening another person. Now that's really important. We draw a distinction between simply maybe offending them, but you can't harm them. You can't threaten somebody. And that came up again when we were looking at the Racial and Religious Hatred Act of 2006. I'm going to try not to go into this in too much detail. But remember, we talked about a patchwork of laws that protect your rights. Well, one of those is the Public Order Act of 1986, which made it straightforward and quite rightly illegal to be threatening, abusive, or insulting on the basis of race. So this essentially said that racial hatred is against the law, and that extends to abuse and threats and insults. Now, what the Racial and Religious Hatred Act wanted to do was to take religion and add that to this bit here. So threatening, abusive being the key thing here, and insulting. And the House of Lords stepped in and said, no, we do not think that is a particularly good idea. We do not think that we should draw an analogy, or we should draw a line linking racial hatred with religious hatred. The simple their argument essentially being that one is a matter of choice and the other is not. And so the House of Lords requested that yes, we retain any clauses in this bill about religious threats where religion is threatening, but abusive and insulting, we think we have to deal with. That is the price you pay for being in a Western liberal democracy where people do have their freedom of speech. And so when the Racial and Religious Hatred Act was ultimately passed, as it was, then threatening words, any threat on the basis of religion was included within it, but abuse and insults were outside. So in other words, while you can't threaten somebody on the basis of their religion, according to law, you do have the right to insult and offend them. And in fact, they went further and went back to the Public Order Act of 1986 and made it clear that antipathy, dislike, ridicule, insult, abuse of a particular religion or belief practices is not illegal. So you can't do any of that on the basis of race. You can't ridicule or express antipathy or dislike or abuse on the basis of race. However, they made it clear that in that Public Order Act, there was nothing there that was preventing expressions of antipathy, dislike, ridicule, insult, abuse of particular religion. You couldn't threaten, which is perfectly reasonable, but abuse, antipathy, dislike of religion is entirely within the law. And again, this is what it means to live in a parliamentary democracy. Our rights are established by Parliament. And if you have a problem with that, then obviously the democratic solution is to vote for somebody else next time. But the House of Lords in particular felt that it was important that freedom of expression should extend to challenging religion. Not race, obviously, because race is not a question of choice. And indeed, the two religions where race and the two races and the two instances where race and religion are considered to be so close as to be aligned entirely is Judaism and Sikhism. And so Judaism is covered by the Racial and Religious Hatred Act, as is Sikhism, in a way that Catholicism and Protestantism and Islam and Zoroastrianism isn't. Anyway, I did say I wasn't going to spend too much time on that, and I've probably done it anyway, but I do find it fascinating. And again, it's a very, very important idea there of how our laws are written by Parliament. Our rights are described by laws written by Parliament and subject to review in Parliament and indeed in the marketplace of ideas, which is kind of what I say here. So, rights are described by laws written by politicians, they're upheld by a neutral independent judiciary, and they're subject to ongoing discussion in the marketplace of ideas and indeed in that free media. A few important laws that have shaped the rights. When we were talking about that patchwork, we start off obviously with the 1998 Human Rights Act, very, very important. That says human rights, as you can quite clearly see. We can then add to that more laws. The Freedom of Information Act of 2000 about finding out what public what information is held on you in public and other bodies. 2001 Anti-Terrorism Crime and Security Act. This allowed the government to inter indefinitely individual foreign nationals who could not be safely deported. Indefinite detention without trial, quite a scary thing. We will come back to that. In 2003, the Sexual Offences Act brought in line the age of consent for homosexual sex with heterosexual sex, as well as creating a new sexual offence between minors and adults, tidying up the law essentially. 2004 Children's Act, another important law that we got going on through there. Serious Organised Crime Police Act, remember that, we come up with that later when we talk about Brian Hoare and the way in which the law established certain areas in the UK of sensitivity where protests could only occur with prior police permission. Very important, that one. I do like it. We talk about it later. And if you've ever seen the video for Taking Liberties, I'll try to remember to link off to that one. That becomes really relevant there. Equality Act tied up lots of various bits of legislation, including the Disability Discrimination Act of 1995 and various other bits of LGBTQ plus legislation, but not, of course, gay marriage. That came through in 2013. 2015, we've got Modern Slavery Act, again, very important human rights thing. GDPR, our old favourite there, we all know about at school. And 2020, finally, the Coronavirus Act, that basically allowed the government to trample over any rights that you thought you might have had for as long as the pandemic lasted. So this is the patchwork of legislation that describes our rights. It's not a single right. I mean, not a single bit of legislation. The Human Rights Act is the single most important one. But what we can see here is that the government can ask Parliament to add to our rights, or indeed to take those rights away, as happened in 2020. So, yeah, what are our rights? Well, they're written by Parliament, and they are then upheld by a neutral and independent judiciary. So here's some more important cases coming through. We've got the Belmarsh detainees. Now remember, we talked about the Anti-Terrorism Crime and Security Act of 2001. Well, in 2004, the Court of Appeal, which in that time was the House of Lords, the Supreme Court not yet being established, the House of Lords said that this law, the Anti-Terrorism Crime and Security Act, was incompatible with our obligations under the Human Rights Act and indeed under the ECHR. And so they asked that Parliament go back and look at it again. So here we see rights being looked at in the courts. The courts are saying, this legislation is incompatible with the Human Rights Act. It required that the barbarians be at the gates for the legislation to be valid. And they said, look, it's not great out there, but I think we can all agree that the barbarians are not at the gates. And so this legislation is incompatible with the Human Rights Act. 2004, Liaka Chindamo. I'd just been teaching for a little while. I remember this one coming through, and so it's kind of seared into my brain. Terrible incident. A headmaster was murdered by a gang outside the school in West London. Liaka Chindamo was the leader of the gang. He was put into jail as a minor. When he came out of custody, the government wanted to deport him. And it's a long and complicated story, and I'm going to cut to the chase. It sort of anyway. As far as we're concerned, his rights, the courts held, were infringed by the government's decision to deport him, because they wanted to deport him to Italy, but he wasn't Italian, and so they said, "Look, you can't do that. It's just not fair." And so Liako stayed in the country. It didn't end well, but that's a whole different story. 2006, we've got there Brian Hoare. Now, we mentioned earlier that the Serious Organised Crime Police Act established a protest zone, or a special zone around Westminster, where you could only protest with prior police permission. Brian Hoare had been a thorn in the side of the Blair administration for some time, and so they passed this law. David Blunkett at the time saying, well, it's maybe a hammer to crack a walnut, but he's quite a tough nut. So they passed the law. The police came along shortly afterwards, bundled Brian Hoare into a van, and a few days later he was back on Parliament Square, because the government made a terrible mistake. They'd said when they passed the law, when they'd asked Parliament to pass the law as they presented to Parliament covered only future demonstrations. It didn't actually cover any presentations that were ongoing. So Mr. Blunkett, he was a tough nut, tougher than you, clearly. But there we go. That was Brian Hoare in 2006. 2010, another deportation case, another case of the Human Rights Act being used to stop a deportation. Abu Hamza, by all accounts, a thoroughly nasty piece of work, wanted to be deported to the United States. He feared he would be executed if he arrived in the United States, and so the Human Rights Act simply said, look, we can't deport him until the United States said that they promised they weren't going to execute him. And so, yeah, we bundled him on the plane and off he went. 2012, Nicholson. I'm going to talk about this in the next slide, so not so much about that right now. But finally, Shamima Begum. Again, I'm going to link off to another deep dive that I've done into Shamima Begum and the various laws that saw her engaged in a pretty desperate situation in a prisoner of war camp in Syria, if I remember correctly. But again, key point that I want to get across here is the laws are passed. So our rights are defined by laws passed by Parliament and then upheld in an independent judiciary, an independent and neutral judiciary. So here we see various cases, sometimes where the courts are finding for the government, sometimes where the courts are finding for the individuals. Nicholson. This was a very, very interesting case, particularly for those of you who are looking at American politics and you're thinking about the way in which the Supreme Court in America seems to be answering so many political questions. Well, here the Supreme Court was asked if the Suicide Act was compatible with the Human Rights Act or the ECHR. I don't want to get into this into massive detail, and you can read what it says there, and indeed you can go off and look at the actual judgment yourself. It's absolutely fascinating. Anyone who's interested in looking at law, I would urge you to do a deep dive into this, because it will give you plenty of things to think about and write about when you come to do your various applications. In essence, the situation in the UK is a bit of a fudge. We have the Suicide Act, but no one has really been prosecuted under the Suicide Act for a very, very long time, because it kind of suits the interests of the government and Parliament to maintain this fudge. Various campaigners obviously are not so happy with the fudge, because it causes a huge amount of suffering to people who are unable to end their own lives. And the Nicholson and his estate essentially tried to ask the court to say that this situation was incompatible with the rights as described by the Human Rights Act and the ECHR. And the court said, no, we can't do that. You're asking us a political question. You're asking us if this law is right, and we can't do that. There is sufficient wiggle room. Oh gosh, it sounds really glib, and I'm do apologise. But there is sufficient latitude within the Human Rights Act for us to say that this legislation is compatible. Taking it further and saying that we need to change the law is a decision for politicians, and we're not politicians. So essentially, they were asked a political question, and they said, look, this is a political question. You need to ask this of your politicians, not of our lawyers. Now, the reason why that's relevant is because, of course, in the United States, you've got Baker versus Carr of 1962, which is when the Supreme Court memorably entered the political thicket, and they have been struggling to get out of there ever since. So this was our Baker versus Carr moment, but the Supreme Court said, no, this is a political decision. It needs to be answered by politicians. And that decision went to the European Court of Human Rights, and they kind of came to the same conclusion. Again, you can read that if you like. Now, lots of things to link off here, and I will make sure that I put all of those in the description. I hope you found that interesting. I hope you found it helpful. It is a complicated subject. But if you can just absorb that laws in the UK are described by, rights in the UK are described by law, upheld by court, and subject to ongoing debate and discussion, then you can't really go wrong. Questions and comments in the below the line. Like and subscribe, and anything else you'd like me to cover, do please let me know. But yeah, I hope you found that interesting. It's one of my favourite subjects, and if it's any consolation, this version is a lot better than my first draft, so that's good news. Yeah, cue the music, and see you in the next video. It's on the executive. It's going to be a big one, and I'll see you then. Take care now. Bye.